Good morning, everyone. Thank you, Wendy, for the introduction. So as Wendy said, my task here today is to take you through this part of the new frontier that we call arbitration and climate change. And it will be a very quick overview, like a helicopter perspective, I guess, or in these days, a drone perspective. But obviously, you can find more details in the paper on the ICCA website. So when we talk about international arbitration and climate change, in many areas, this is a terra incognita. And as many of you might know, that other terms used to describe uncharted territories on maps is here be lions or here be dragons. And I think there are some potential dragons and lions out there, but only if we not address this uncharted territory. Only if we not explore how we can use our expertise, that of international arbitration, to contribute to the climate change efforts. I think the climate change crisis is a situation that truly requires all hands on deck. Now, the navigation along this new frontier will take us through the familiar waters of public international law. But unfortunately, public international law will offer limited tools for navigation, although the archipelago of investment arbitration and climate change offers an interesting scenery. This journey will also show us that international commercial arbitration is as important as ever. And as we move into the truly unmapped regions of the new frontier, we need to apply all our knowledge, all our skills, all our expertise, common sense, to arrive safely at our destination, a territory where international arbitration truly can contribute to and make a difference for climate change mitigation and adaptation efforts. And we have to use all our skills in arbitral procedure, but be innovative when we apply this procedure. And we also, I think, need to widen our perspective and confer with the other experts on board on this journey to use their skills and their expertise. So if you are the international arbitration expert steering the ship, you might need to consult with the climate change law experts on board before you decide on the course for your journey. And finally, we might find on this journey that in fact we do not yet have all the tools that we need to navigate. We will have to invent them as we travel. So you might ask then, does this frontier really exist? Is this journey necessary, or is this all in our imagination? Well, I am not a climate change scientist, but fortunately, I don't have to be. I can learn from those who are. In 2015, a review of 69,406 peer-reviewed articles on global warming revealed that 0.005% reject global warming caused by human activities. So that's 69,406 articles with 0.005% rejecting global warming caused by human activities. If that is not convincing, I think reading the news is. So climate change has the potential of causing, and already is causing, a number of things. For example, increased tension between countries due to scarcity of water, forced human migration, and displacement caused by rising sea levels, massive spending to cover the costs of floods, droughts, and other extreme weather events. And unfortunately, this list could go on. I believe that where climate change is the cause of geopolitical conflicts, international arbitration can make important contributions to untie the knots, as it has done in the past. I think international arbitration can contribute and continue to contribute to human coexistence, also when societies are destabilized as a direct or indirect consequence of climate change. But is there a role to play for international arbitration also in efforts directly addressing climate change? This is what we will try to find out, and as promised, we will start our journey through the waters of public international law. Now, a speech about the role of international arbitration in the relatively small body of law known as international climate change law potentially could be very short, because at a glance, arbitration really does not play any role at all in this area of law. The United Nations Framework Convention on Climate Change, the UNFCCC, resides at the center of the climate change law regime. And together with additional instruments that have been negotiated by the parties to the UNFCCC and the annual yearly Conference of the Parties, or the COP. Now, household names, results of these annual meetings are the Kyoto Protocol and, of course, the Paris Agreement. Now, the implementation of the UNFCCC is governed by countries reporting their performance under the convention. And this is pretty much in line with almost all the international environmental agreements. In general, they tend to rest on a mechanism for transparency for enforcement. Now, Article 14 of the UNFCCC does foresee a mechanism of arbitration that the parties to the convention can accept. However, there are no rules on the arbitration yet in place, and this is referred to future conferences of the parties to agree on. But so far, no conference of the parties have yet done so. The hugely successful Paris Agreement, as Wendy described, is the result of the very successful conference of the parties in 2015 in Paris. Under the Paris Agreement, each signatory shall, for example, report its intended climate actions for the purpose of reducing greenhouse gas emissions. This is also called the Nationally Determined Contributions, or the NDCs. Now, the Paris Agreement does not include any obligation on the result of the NDC, so this is an obligation on procedure, not on result. The Paris Agreement also foresees a mechanism to oversee the implementation and compliance with the agreement, but as in the UNFCCC, there are no firm procedures in place for this yet, and arbitration is not part of this picture. But when it comes to enforcement, the UNFCCC and the Paris Agreement are not unique. The territory of climate change law and public international law simply offers very limited support for the use of international arbitration or any other binding enforcement mechanism. This has simply not been possible from a political standpoint to agree during the negotiations. So to find out more about international arbitration and climate change, we need to move further along this frontier. And we enter into the domains of international investment law. And as we do this, the landscape shifts character. Now, this audience, many of you, of course, are no strangers to international investment law or investment arbitration. Now, so one question that could be asked is, could the standards of investment protection in bilateral investment treaties, together with the added force of international arbitration, and you find these in almost all of the 3,000 or so bilateral investment treaties that have been concluded, could these standards, together with the force added by international arbitration, be a force of good to address climate change? This is an area worth exploring. For example, in the case Peter Allard versus the government of Barbados, the investor argued that the state had failed to fulfill international environmental obligations and that this constituted a breach of the standard of full protection of security under the bilateral investment treaty between Canada and Barbados. From time to time, the question has also been asked if the standard of full protection and security could include an obligation on behalf of the states to prevent damages by extreme pollution. This issue was raised, for example, in 2015, when haze originated from forest fires caused extreme air pollution in several countries in Southeast Asia. If the standard of protection and security does include an obligation to prevent damages caused by extreme pollution, does this also include an obligation to take all necessary steps to prevent damages caused by greenhouse gas emissions? This is an open question. Like I said, the archipelago, or the landscape of investment arbitration and climate change, offers an interesting scenery. But in this archipelago, parallel international ambitions and obligations also sometimes cross paths, or, as some would argue, clash head-on. I'm talking here about investment arbitration relating to investments in renewable energy. Renewable energy is an important building block to a low-carbon society. And currently, we are seeing a global growth for investments in renewable energy. But oil, gas, and coal still account for about 86% of the world's energy mix, a share that has barely changed in the past 25 years. So even if investments in renewable energy are on the increase, we need more, much more. But at the same time, there is a rising tide of claims against states under international investment law based on investments in renewable energy. In many jurisdictions, investments in renewable energy have been supported by feed-in tariffs and other incentive schemes. And as policy has shifted, these programs have been revised. This is the background to many of the cases that we are currently seeing, including at the Arbitration Institute of the Stockholm Chamber of Commerce. And just to be clear, what I'm saying here is all in the public domain, so I'm not revealing anything confidential, in case anyone was wondering. Now, is climate change part of the picture here? Some of the awards mention emission targets as part of the factual background of the policy, which is the subject of the Arbitral Tribunal's review. But none of the awards specifically contain any factual conclusions or arguments relating to greenhouse gas emissions. It appears this has not been argued, and neither has any international obligations relating to climate change mitigation. If there is a potential junction between international investment law and climate change law, it remains unexplored. But perhaps this unpopulated area at the new frontier one day will see an arbitral tribunal passing by. But for now, we'll leave the interesting scenery of international investment law and climate change and move into the more familiar waters of international commercial arbitration. The private sector and private investments play a decisive role for climate change mitigation and adaptation. And with this also the agreed legal frameworks of international trade and economic development, including, of course, international arbitration. The investments needed for climate change efforts are diverse and global. For example, a growing world population and raising living standards will have to meet global demands for energy, a rise for global demands in energy. And renewable energy plants, to a large extent, will have to replace carbon-heavy energy plants. We need energy-efficient transportation to carry an even more global and growing world population, and so on. In 2017, the OECD estimated that a total investment of $3.6 trillion would be needed annually to cover climate change mitigation and adaptations until 2030. That's a large number. And what can arbitration do in this scenario? What it has always done: provide certainty, enforce contracts, be that enforcement bar of the structure of economic development that it has been so successfully in the past. But business as usual will not be enough. And this is when we move into the truly unmapped regions of the new frontier. And we can begin by choosing the trail of procedure. Along this trail, a first stop could be the principle of confidentiality. We could ask ourselves if the inherent characteristic of confidentiality in international commercial arbitration is a hurdle for arbitration's capacity to play a role for climate change efforts. We know from international environmental law that transparency is a driver for change. And in recent years, publicity surrounding climate change litigation has contributed to climate change awareness. Should we consider deviating from the norm of confidentiality in cases where you have a climate change element? And now a parallel, of course, can be found in the debate preceding the UNCITRAL rules on transparency for treaty-based investor-state arbitration and later the Mauritius Convention. And even if not all cases with the climate change element involve a public interest, there could still be valuable or even inspiring details to be shared on how the private sector, in fact, is building a low-carbon society. A second stop along the procedural trail could be the applicable law. Could the interpretation of provisions or applicable law be expanded to address all issues of relevance for a particular dispute, including laws or rules of law regulating matters relating to climate change? Where a dispute has consequences beyond the immediate parties, arbitral tribunals might need to consider a wider interest when calibrating standards. At least this is a view that has been argued, for example, in relation to human rights. Could the same argument be made for climate change? Another trail of interest in the new frontier could be the new models for international agreements. We know that the private sector will play an important role in climate change mitigation and adaptation efforts. But it remains the tasks of governments to provide a stable policy framework. A recurring theme post the Paris negotiations in 2015 has been that yes, the money for these green investments exists, but investors are hesitant to make the commitments in the absence of stable and transparent legal frameworks, including reliable enforcement. Today, there is no international legal instrument that specifically incentivizes and protects investments aimed at climate change efforts. So new models and new agreements are needed. Agreements that address the specific needs of states as a consequence of climate change, while at the same time providing long-term certainty for the investors. This is the background for an initiative in Stockholm we call the Stockholm Treaty Lab, which is a global competition where we use crowdsourcing to draft an effective legal instrument for climate change efforts. And the objective with this initiative is to create a new model for an international treaty that creates transparent, stable, and enforcement policy to incentivize investments as foreseen under the Paris Agreement. And by using crowdsourcing, we use all the brilliant minds out there globally to help us solve this problem. This competition is underway, and I am very pleased to report that there appears to be a global and interdisciplinary consensus that this is a gap that needs to be bridged. And speaking about institutional initiatives for climate change and arbitration, I also want to mention the recently formed the ICCA Task Force on Climate Change and Arbitration, which just started its work, and Wendy is chairing, and as a member of the task force, I'm really looking forward to what we can do in this task force. So, as I have tried to illustrate, there are many ways in which we together can explore the hidden potential of international arbitration and also potentially then make climate change a little less frightening. And I would like to end my remarks here today by using the concluding words of the UN Secretary General Ban Ki-moon at the ICCA Congress in Mauritius 2 years ago, when he said the following: I ask all of you to use the great power of arbitration to help the world overcome conflict and hatred and build a future of dignity for all on a healthy planet. Thank you.